I just
Connect.
put us on. Welcome to the colloquium, everyone. It's a great pleasure that I invite Professor Atul Sood from the Center for the Study of Regional Development, Jawaharlal Nehru University, New Delhi, to give the talk this afternoon. His talk is titled "The Silent Takeover of Labor Rights." As those of you who might have seen the invite already know, Professor Sood has worked extensively on the issue of labor-capital relations in the country. His early work focused on Punjab, and he's co-authored a book on the Punjab crisis in the mid 80s, 1984 to be precise. He's recently edited a book called Poverty Amidst Prosperity: The Trajectory of Development in Gujarat, which tried to take an objective look at the idea that Gujarat as a state had developed on many fronts. Yes, and he's written numerous articles that will be of interest to those interested in the question of labor in the country, in especially in the pages of the Economic and Political Weekly. With that short introduction, I invite Professor Sood to give us the talk this afternoon. Thank you, Professor Sood.
Well, thank you, Professor Chandan Gaura, to have asked me to come and speak. I got introduced to Chandan as he invited me, and as I followed his work, I realized, he's an erudite scholar, and it's a matter of great privilege that he asked me to come and speak at this colloquium this afternoon. I have tried in my work in the recent years to engage with issues that support those who are working towards building a more equal and just social and economic policy order in this country. And my work on labor laws is part of this project. I must also say right at the beginning that my work on labor, like with many other work that I have done, is a teamwork done with range of people, in particular my students, one of whom happens to be your colleague and who has been one of the main collaborators with me and a co-author with the work that I have done, Dr. Paritosh Nath, who now works at APU. We have done jointly work on labor issues. And in fact, substantial part of my today's lecture would be borrowing from our joint work. I hope that you'd find some of the things that I say today of interest. Many of you would already know the range of issues that confront us in the field of labor and labor studies. Let me begin my talk by saying that you all know that in the last few months, specifically before September 2020, about 44 labor laws enacted by the central government that dealt with wages, social security, labor welfare, occupational safety and health, and industrial relations existed in this country. And along with these 44 laws, there were about 100 state labor laws. Since you all know, labor is on the concurrent list, so both central and state governments have the power to legislate on labor. So about 44 legislations dealing with labor issues were enacted by central government, and about 100 by the state governments were in operation. These laws were historically enacted on the basis of a process of tripartite consultation or on the basis of report of various committees which had heard representations of all stakeholders, as one would say. Something happened in September, and we need to answer what happened in September 2020, that this silent takeover of labor rights happened. As I call it, the silent takeover. I mean, how do we make sense of this change? I have tried to make sense of this change, of this suddenly, these 44 and 100 labor laws, 44 in particular and about 100, the future is uncertain, suddenly going away from the map of labor legislation in this country. So something must have happened, as I suggest, just in the months and days preceding September, or in September, it must be a culmination of a continuum or a process or a direction of change that was expected. Unfortunately, the answers to both these questions are not straightforward. If you look at the major events preceding the month of September, You all remember that there was this outpouring of sympathy from the people of this country for the migrant workers who had suffered extraordinarily during this period of COVID-19 lockdown. The precarity of India's working poor and working people was witnessed by the entire world within 24 hours of the lockdown in the end of March 2020. Women, small children, men with no prospect for work and wages in the cities, small vendors, domestic help, agricultural laborers, sanitation workers, casual laborers, and contract workers in factory and workshops who lived in both cities and rural areas. For all of them, livelihood came to a grinding halt, pushing them into a state of extreme vulnerability. So that was the context in the early months of before September. With the country witnessing workers escaping from the cities, citizens of this country saw the Indian state, the Indian government, violating its own laws with immunity, in particular, with impunity. In particular, the law on migrant workers, the law on construction workers, the Supreme Court orders on payment of wages during the lockdown. Hundreds got killed during the punishing journeys to their home states, mainly on foot, but also in crammed trucks, auto rickshaws, and small carriers. In fact, Azim Premji University's Center for Sustainable Employment has put out a compilation of survey of migrant and other workers that captures the impact of this lockdown. And it suggests that about 66% of the surveyed workers had lost their jobs. 77 were consuming, households were consuming, 77% of households were consuming less food than before, and 64 were earning less than before. The Center for Monitoring Indian Economy estimates job losses that out of a total of 87 million salaried jobs in existence, 21 million lost these salaried jobs during the lockdown, a job loss of nearly 25%. Of those worst affected have been the white-collar professionals such as engineers, physicians, etc. In addition, 26% industrial workforce also lost jobs during the lockdown. Now, it's worth asking, therefore, whether the new labor laws that were introduced in this country, or labor codes introduced in this country in September, create hope for those who lost out during the lockdown, or did it prepare them or prepare India's labor force to face such future shocks as the COVID-19 pandemic in any other different, substantial, better way or not? The second question that we could be asking to understand this change in September, as I suggested earlier, was that this change in September just happened to be the cutoff month, but what was not sudden. The fact is that the central government has stated over a period of time that the 100 state laws and 40 central laws regulating labor, various aspects such as resolution of disputes, industrial disputes, working conditions, social security and wages, they need to be altered. The Second National Commission of Labor 2002 found existing legislation to be complex with archaic provisions and inconsistent definitions. So to improve the ease of compliance and ensure uniformity in laws, the Labour Commission did recommend consolidation of labor laws into broad groups. And the groups it suggested were industrial relations, wages, social security, safety, welfare, and working conditions. In 2019, the Ministry of Labour and Employment introduced 4 bills to consolidate 29 central laws. These codes regulate A, wages, B, industrial relations, 3, social security, 4, occupational safety, health, and working conditions. While the code on wages 2019 was passed in the parliament, bills on the other 3 areas were referred to a standing committee on labor. The standing committee has submitted its report on all the 3 bills in the month of, I think, June or July. The government, when it came with these bills in the parliament in September, replaced these bills with the new ones. So the 2019 bills and the 2020 bills or the codes are distinctly different. And the PRS website provides a very useful table to compare the 2019 proposals and 2020 proposals. So at one level, as I suggested, that the context was the lockdown, or if you look at in terms of what was happening over a period of time, the context was this process of consultation that was going on, and which had started with the recommendation of the Second Labour Commission. So what happened now that suddenly the state and the Indian state as well as the industry have turned their backs or on the workforce by backing or approving these appalling anti-worker legislations. And I will elaborate why I say so. See, in the history of independent India, the passage of labor laws to protect workers had involved long and difficult struggles of the working class. However, in one stroke, the government intends to put last nail in the coffin of labor protection. Sadly, I must say, I must confess that I'm not surprised that no consultation with the representatives of the worker nor state governments was done while drafting the 2020 codes. In fact, I will later on come and make the linkage with the farm laws. So when there is so much discussion about committees and consultation, the recommendations of the Standing Committee on Agriculture Marketing was never utilized when it came up with the farm laws. And the Standing Committee recommendations on labor codes was also not utilized or was not consulted when proposing the codes, labor codes for 2020. And I'm again, as I said, I'm not surprised because the present political regime had not organized the highest tripartite labor policy decision-making body, which is the Indian Labour Congress, for a single time in the last 6 years. So basically, it suggests that the Labour Union government does not believe in extending the democratic decision-making process to the working class, else it would have called the meeting of the Indian Labour Congress. To me, therefore, the coming of a bills in month of September and as distinct bills or distinct codes from the 2019 proposals was not a surprise. The continuity need not be seen only in the process of consultation, but also whether this continuity in terms of what was being done before and what was done in September, does it also reflect the reality of India's labor market? In the sense, does the continuity also ought to be seen in terms of, does it respond to the challenges of the India's labor market? If we do a simple stock taking of the labor market conditions in India, the periodic labor force survey 2018-19 captures the conditions of the labor market prior to the COVID-19 crisis. The PLF results tell us how the majority of the workforce in India was precariously employed as unpaid family labor or as casual labor with no stability of income or as regular workers with no social security. So the three characteristics of the labor market are very clear here. Precariously employed as unpaid family labor, casual labor with no stability of income, or regular workers with no social security. The survey also tells us that there is a compelling need to improve women's absorption in labor force. And the question is that these hurriedly passed bills do not respond to this reality, which is the current reality of India's laboring poor. So we need to ask how these labor laws will help us bring back the lost jobs, create employment for women, improve the participation rates, and improve the precarity of self-employed. So none of these developments, both in terms of the inputs from previous committees or various stakeholders or the actual challenges of the labor market, appear to have influenced the legislative change in labor laws. This is not only evident from the content of the bills, as I will elaborate in few minutes, but also from the fact that the government did not deem it important to offer any defense or explanation for these changes. No rationale was provided. It was assumed that the larger common sense that had been manufactured by the media in the country over the years is a sufficient ground in defense of these bills. And what is that common sense? That common sense being that to construct a policy environment in favor of the investors and the factory owners at the cost of the labor. The essential idea being that what facilitate investments will bring growth, and as growth is achieved, first, jobs are a consequence. And therefore, labor and inefficiencies of labor market make India uncompetitive, and specific initiatives to deal with the precarity of India's labor force is not required at the moment, but it is this, or to look at issues of labor, lack of labor participation by marginalized social groups. Rather, the focus should be to address these regulatory changes, which makes in quotation marks, India competitive in the world market. So other than claiming that these labor laws will create a favorable regulatory environment for factory owners and therefore bring growth, there is no connect of these changes in the labor codes with rebuilding of the economy. As far as investments are concerned, in fact, as far as investment is concerned, the argument about labor cost is concerned, the issue of compliance cost is concerned, and also the argument about simplification of labor rules is concerned. Paritosh and I have this EPW article where we look at these questions in great detail. I don't have the time to give evidence, but our argument essentially is that often the comparison is made between India and China and how India is uncompetitive vis-a-vis China in terms of labor costs. A simple, quick Google will tell you that labor costs in China are, 3 times higher than India. Indian labor costs are already low. The talk about compliance cost is also very interesting because compliance cost in simple language is corruption. So we don't want to do anything about corruption, but we want to deregulate the labor market. The whole issue of the fact inspector Raj, well, if you look at the inspection rates in this country, in the organized manufacturing sector, the ASI data, mid-90s, we were inspecting 50% or more than 50% of factories. Closer to the current years, we are inspecting less than 10%. So the inspector Raj has already been diluted. The issue of simplification, as I elaborate on each codes and come up with the issues on each codes, you will realize to what extent we have simplified and to what extent we haven't. So my argument is that, the common media discourse supported by the government and supported by the industry and capital in this country, that the reasoning for changing the labor codes actually does not apply to what the change has done. It is interesting that even those were not argued, or when the government introduced this sudden change in September, which was distinctly different from the consultative process, what the consultative process was recommending from the past, the government did not come up with any rationale or any explanation. Okay. Now, let me come to the specific codes. The first one I want to sort of, go in some detail is the Code on the Industrial Relations, 2020. This is a new code that consolidates and amends the laws relating to trade unions, conditions of employment in industrial establishments, and investigation and settlement of industrial disputes. So that's the broad coverage. The key essence of this change, as I read it, my reading of it is, A, to minimize government's regulatory role, and 2, to reduce the possibility of oversight. And these 2 goals, to minimize government's regulatory role and reduce its possibility of oversight, has been achieved by making numerous changes and also introducing new ideas, changes from what existed in the past and also coming up with new ideas. And as I elaborate, please do notice the argument about simplification, that when we did the consolidation from 44 into 4 codes, what did this consolidation really mean in terms of simplification? So the changes in the definition of employer, employee, worker taken together in the codes, industrial relations code, is confusing, self-contradictory, and untenable. Although the employer includes the contractor is not defined in this bill. Now, we can define the contractor from borrowing the definition of contractor from the Social Security Bill. Now, if you borrow the definition of contractor from the Social Security Bill, then this opens up the possibility of a lot of sham and bogus contractors. The definition of principal employer is ambiguous and could include contractor as well. The employer may be one directly employing the person or the individual who has the ultimate control of affairs. These need not be same. As a result, it might not be possible for workers to pinpoint the responsibility of an employer on any one person. The code also gives greater freedom from regulatory control to factory owners and strengthens the unequal bargaining power of employers and limits the role of trade unions. Interestingly, the government has given itself the power to exempt any new industrial establishment or class of establishment from the provisions of the code in public interest. and you understand what public interest is. The provision of establishment to prepare standing orders on matters related to, and it's interesting, related to informing workers about working hours, holidays, wage rates, termination of employment, grievance redressal mechanisms, classification of workers will apply to establishments for more than 300 workers. The government has this concept of standing orders. And interestingly, the government has also come up with rules and regulations that follow the code. So where government elaborates how will we implement this legislative framework. And there the government has proposed, that came in month of October, where the government has proposed that it will come up with a model standing order. So it will come up with, the model, like the Model Agriculture Marketing Act, which no one implemented. So the government is going to come up with a model standing orders for factories employing more than 300 workers, which will tell the workers about working hours, holidays, wage rates, termination of employment, grievance redressal, and so on and so forth. The Parliamentary Standing Committee, which was being consulted before, that is the earlier process, said that this would apply to establishments with more than 100 workers, but that was suddenly changed to 300 workers in the September proposal. Likewise, the new law provides that prior information of the government before closure, layoff, retrenchment will be required for establishment with at least 300 workers and not 100 workers, as was the case earlier. The code allows for an increase in the threshold, that is this threshold of 300, through a notification, but does not allow the lowering of the notification. So the government can learn, but the learning is in one direction. It can increase for which this law is applicable. The new law, however, lowers the threshold to be recognized as the sole negotiating union to 51% from 75% of workers in any establishment that has more than one registered trade union. So who would negotiate? Earlier the cutoff was 75%. Now it's 51%. The definition of strike has been broadened to include concerted casual leave on a given day by 50% or more workers employed in an industry. This constrains workers' ability to participate in collective bargaining process and demonstrations. In addition, there are several restrictions to strike. Workers will be subject to penal sanctions for mere fact of organizing or participating in a peaceful strike. Imposing such sanctions on strikes that are justified amounts to grave violation of the principles of freedom of association. The code also weakens collective bargaining by prohibiting strikes and lockouts in all industrial establishments without giving notice, with a further proviso that no unit shall go on strike in breach of contract without giving 60 days before the notice, 60 days notice before the strike, or within 14 days of giving such notice, or before the expiry of any date given in the notice of the strike. So there's a very strong framework within which you can give. It further says that there shall be no strike during any conciliation proceedings or within 7 days of the conclusion of these proceedings, and these conciliation can go on for a long time, or during proceedings before an industrial tribunal, or 60 days after the conclusion, or during the arbitration proceedings. The Industrial Dispute Act 1947 had placed restrictions on announcing strikes only in public utility services. However, the new code extends it to all establishments. Any violation of these provisions of notice period can lead to a strike or a lockout as classified as illegal. The curtailment of rights actually descends to new depths in the code with the section 64, and it's very important, that states, no person shall knowingly spend or apply any money in furtherance or support of any illegal strike or lockout. So all of you be very careful. If you support any strike and that strike gets declared to be illegal, then you've also indulged in an illegal activity. The Industrial Relations Code replaces various industrial courts and tribunals with 2-member labor tribunals, one with judicial and one with administrative member, which dilutes the legal safeguard for workers. In case of maternity benefits and settlement of claims for injury and disability, the power to educate and settle entitlement stays with an authority nominated by the government. The maximum imprisonment for obstructing inspector from performing his duty, all of that has been changed. Collective bargaining is further weakened by changing the definition of a dispute or a settlement to include individual disputes. There is a whole range of committees that this code proposes. There's something called, and please notice for simplification, I'll take 2 minutes more on this code, works committee. In any of the industrial establishment in which 100 or more workers are employed or have been employed on any day in the preceding 12 months, will have a works committee. The government will notify which organization will have a work committee. Uh, and in such a manner as prescribed by the government, constituting representative of employer and workers engaged in the establishment. What is the duty of the works committee? And that's very nice. To promote measures for securing and preserving amity and good relations between the employer and workers, and to that end, to comment upon the matters of their common interest or concern, and endeavor to compose any material difference of opinion in respect of such matters. And the works committee will have, irrespective of the scale of the establishment, 20, 10 from the employer side and 10 from the worker side. The trade union can also nominate people in this works committee. Then there is grievance redressal committee. Every establishment employing 20 or more workers, that was for 100 or more workers. Now for 20 or more workers shall have one or more grievance redressal committee for resolution of disputes arising out of individual grievances. And I earlier told you that is impacted the collective bargaining. The maximum number of people in the grievance redressal committee will be 10. There are complex rules that have been laid out in the new rules that have come about of who will get nominated. So, for example, the grievance redressal committee will be chaired by the CEO, but the vice president will be elected from among the members that are of the workers who are nominated to the grievance redressal committee. But when it comes to the secretary of the grievance redressal committee, he will be elected by all the workers, and so on and so forth. It's a very complex process. Any workers who's aggrieved by the decision of the grievance redressal committee or whose grievance is not resolved by the said committee within 30 days of receipt of these applications may file an application to a Samadhan portal. Ministry of Labor and Employment run this portal, or by a registered post within a period of 60 days, etc. Or from the date on which period specified under this clause, as the case may be, to the conciliation officer through the trade union of which he is a member. So he can apply via trade union to this Samadhan portal. No trade union workers shall be registered unless at least, no trade union of workers, shall be registered unless at least 10% or 100 workers, whichever is less, is engaged or employed in the industrial establishment or industry with which it is connected. Which is connected are members of such trade union on on the date of making the application for registration. So 10% or 100 workers, whichever is less. The process of registration and cancellation, I don't have the time for a trade union, does not facilitate the existence of a very union. There shall be a negotiating union or a negotiating council. So as if the works committee, grievance redressal committee, the complication of registering a trade union, then the complications of cancellation of the trade union that can be initiated by an employer, all of that, over and above, there is also the notion of a negotiating union or a negotiating council, as the case may be, which is having a registered trade union for negotiating with the employer on such matters as may be prescribed. The central government shall make model standing orders, and I already talked about this. So if you look at the overall framework of the and overall essence of the industrial code bill, as I said, it minimizes government's regulatory role and reduces the possibility of oversight and tilts the institutional arrangements in terms of the capital labor relations very strongly in favor of capital, making it nearly impossible for any kind of workers' resistance. So if in September 2020, we did not find the kind of resistance and the kind of ho-halla that we have seen on farm laws when it came to the changes in the labor laws, we can imagine that once these codes roll on, there would be really no possibility of organized collective resistance against any kind of future legislative change, which might further weaken the labor rights. So it's really, that's why I call it is a silent takeover of the labor rights. Now look at Social Security. This is the Code on 2020, Code on Social Security. It seeks to consolidate existing legislation on Social Security and protections, including, I'm just going to look at the time, Okay. I have about 10, 12 minutes more, right? 15 minutes. The Code on Social Security seeks to consolidate existing legislation on social security and protection, including employees' provident fund, employees' state insurance, gratuity, maternity benefits, and so on and so forth. Now, as it has done so, it has actually dealt a severe blow to labor protections, particularly for informal workers. So, just please see, or please notice that we have this new codes getting introduced in the parliament, getting approved in the parliament without discussion. I didn't elaborate on this. At a time when the precarity of the workers was seen by everyone, and the country was overall sympathetic. The citizens were sympathetic to that precarity of the migrant labor force. We have a code on social security introduced here, which actually gives a blow to labor protections, particularly for informal workers. Despite the historical exclusions faced by workers, including migrant workers, the code does not bolster the social protection and excludes vulnerable workers in many ways. In its provision, the code falls short of safeguarding the interest of unorganized sector workers and articulates a framework of social security that is dependent on the goodwill of the corporates. To begin with, the code does not emphasize social security as a right, nor does it make reference to its provision as stipulated by the Constitution. In addition, it does not stipulate a clear date of enforcement, which means it will leave millions of workers vulnerable without clear social protection. The social sector protections may be ought to be universal for the entire Indian workforce. If we were looking at simplification, they ought to be universal social protection norms. Instead of this, the code makes arbitrary categorization that will leave millions of working poor out of its protection. Let me give, for some example. Section 2.6 retains the old threshold of only those sites with 10 or more building and other construction workers needing to be covered by the code. In addition, personal residential construction work, which forms a large part of daily wage work, is excluded from the provisions of the code. Section 282 retains wage ceiling to define a waged worker. However, such ceilings might be defined arbitrarily, and despite standing committee's recommendation to remove it, the code retains this clause. For Provident Fund, only establishments with 20 or more workers are covered, excluding millions of micro and small enterprises from its ambit. Moreover, employees could misuse this restriction to exclude existing employees from the protection itself. The code defines multiple categories. It's most distressing to note in this code that the definitions have not been revised in the code to determine whether a worker belongs to the organized or the unorganized workforce. For example, gig workers, platform workers are not defined as unorganized workers, even though millions of workers in India are employed as such in gig and platform workers as unorganized workers. Similarly, the term establishment should ensure all workers without discrimination to be included in the ambit of social security protection. The standing committee had recommended the definition of establishment to be altered to include exchange of services with the provision of less than 10 workers. However, the September codes ignore this. In fact, all enterprises without exception should be registered on a mandatory basis with a single body, which should be responsible for the provision of social security instead of being handled by multiple agencies. I thought that would be simplification. Interstate migrants have not been mentioned as a separate category, where there was such a strong need for a sizable welfare fund and contributions by sending and receiving states and employers. The states are now talking about that they will control the mobility of these workers. UP is already initiating such process. There is not even a provision for the portability of social security, which takes into account this continuous movement of workers across countries. There is no provision for a floor social security protection. A model scheme covering health, education, social security, pensions, and other benefits, which could ensure a dignified life for workers as per the rights granted by the Constitution, has no space in this code. There is no consideration for unemployment protection for unorganized workers, which would be very relevant in this time of slowdown and recession. There is also no mention in this of how security contributions would work for a typical arrangement when there is no clear employer-employee relation, including home-based work, self-employment, piece rate work. Historically marginalized groups. Section 4.1 provides no framework to include scheduled caste, scheduled tribes, OBC, and female representatives on the board of trustees of EFPO. There is no specific sectoral representation to include diversity of works within the unorganized sector. The tripartite employer, worker, employee, state board should not be diluted. This was a recommendation of the standing committee, but this has been ignored. Maternity benefits have not been universalized. The court makes it easier for employers to flout legally required social protection for workers. For instance, there is no penalty for non-contribution of PO dues by employer or contractor. There are some penal provisions. On maternity benefits, the details show that no serious thinking has gone into framing the provisions. They categorically state that no woman shall be entitled to maternity benefits unless she has actually worked in an establishment of the employer for whom she claims benefit for a period of not less than 80 days in 12 months, immediately preceding the date of her expected delivery. With women's overwhelming presence in the unorganized sector and self-employed workers, how does this provision ensure maternity benefits for all working women? You can yourself see. In the name of social security for unorganized workers, gig workers, and platform workers, the code has an interesting offer to make. They have an idea of a scheme mentioned in the code, but no details. The code clause 109 on the Social Security Code says that the central government and governments shall frame and notify, in quotes, suitable welfare schemes from time to time for the social security of these workers. If you look at the financing framework of these schemes, this proposal seems to be to create a special purpose vehicle, something like a PPP, using corporate social responsibility funds and contribution by beneficiaries with partial contribution from central and state governments. So government is not willing to take responsibility of social security. It doesn't come up with the detailed framework or the exact entitlements under social security, but does promise an idea of a scheme. In fact, when it looks down to funding these, it is even more clear that it is putting the onus either on the corporate social responsibility funds or the state governments. Now, what the state governments had done in terms of the legislative framework, I mean, we had looked at that question in great detail in the last May 30th EPW paper of the 3 states which said they are in fact even a stronger race to the bottom in terms of deregulating the labor market. Adding insult to injury to the industrial worker is the power that the government has retained to grant exemption to any establishment or employees or class of employees from any provisions of the Social Security Code. So, one, you have diluted the Social Security. You have not ensured that it reaches the lowest, the most marginalized, the workers who mostly need it. And third, you have retained the right that you could exempt anyone from implementing those bare minimal social security entitlements. The Code on Occupational Safety, Health and Working Conditions also intends to amalgamate, simplify, rationalize 13 labor enactments relating to occupation, safety, health, working conditions, and so on and so forth. The Code Occupational Safety, Health and Working Condition excludes many branches of economic activity, most notably the agriculture sector, which employs more than 50% of India's working population. Employees in the unorganized sector such as mines, hotels, eating places, machinery repairs, construction, brick kilns, power looms, fireworks, carpet manufacturing, and those employed as informal workers in organized sector, including new and emerging sectors as IT and IT-enabled services, digital platforms, e-commerce, do not find coverage in the Occupational Safety, Health and Working Conditions Code. The 2019 version empowered the government to prohibit employment of contract labor in some cases where the work was of perennial nature or where the same work is carried out by regular workmen in the establishment. In the 20 Code, it prohibits contract labor only in core activities. So there's a new concept here, core activities. And who will define the core activities? The government will define the core activities. The appropriate government will decide whether an activity of an establishment is core or not. However, the code defines the non-core activities where the prohibition will not apply. These include sanitation, security services, and any activity of intermediate nature, even if it constitutes a core activity of an establishment. So, read simply, contract workers will be allowed both in core activities as well as in non-core activities, subject to some minor qualifications. So, the employment of contract workers has got enlarged in the new code. Chapter 7 of the Social Security Code on hours of work, wages, annual leave seems to be completely oblivious to the reality of employment conditions in India. The chapter mentions only when medical leave, but there is no elaboration on how it will get implemented when regular workers in formal sector increasingly do not have such benefits. Our 2014 paper looks at this question. Significantly, despite the crisis that the migrant labor has faced, this code removes the provision in the 2019 bill requiring contractors to pay a displacement allowance to interstate migrant workers. With regard to interstate migrants, the primary burden has been placed on the contractor, who are themselves marginal players, scapegoat by the principal employers and large industry players. There are moves in the code to enable registration and portability of PDS and other benefits to migrant workers. There's talk of toll-free numbers, and so on and so forth. However, by increasing the threshold of application of these provisions to an establishment employing 10 or more workers, very few of those who are likely to provide any relief or support to the vulnerable workers. The code does not mention intrastate migrants, that is, migrants who work within the states, whose magnitude would be much higher than the interstate migrants, and their vulnerabilities might be equal or even more acute. The Social Security Fund for migrant workers and unorganized sector workers overall is an interesting idea, but it reflects complete ad hocism in the structure, and the resourcing of these funds will be left completely to sources outside the government. So here we have an instance that in spite of this experience of COVID-related lockdown on the working poor of this country, the citizenship rights to migrant workers are not provided by this code. It is disheartening to note that the government has simply refused to acknowledge the invaluable contribution of this labor to India's growth story. The code fixes 8 hours for a working day and provides for women to be employed in all establishments for all types of works. No prohibition of employment for women for undertaking hazardous or dangerous operations. So, historically, what was achieved in terms of that famous report on by the feminists in this country and women's trade unions and gender equality advocates in 1974, suggesting women's working conditions to be improved via where women would not be allowed to work in a factory between 6 a.m. and 7 p.m. and imposed restrictions, prohibitions on women workers to be employed in hazardous occupations. This code takes away that historical gain in just one stroke. It is appalling that the code has gotten away by not fixing any responsibility on the employers with respect to safety and health. It does not specify even minimum standards of occupational safety or health or daily and weekly working hours, and everything has been delegated to the central government to be stipulated via a notification. The enforcement mechanisms have further diluted. Concepts like facilitators, third-party certification have been introduced. Court consistently ignores the fact that workers in the unorganized sector are either self-employed or work in small group. Thus, the threshold of 250 for instituting a safety committee at a workplace is a laughable provision. That will effectively mean that 90% of the country's workforce will not be under any ambit of workplace safety. This is especially critical in a time when about 40,000 deaths are estimated to take place every year in India at work sites. And the carelessness with which the codes and the proposals in the codes have been constructed is shocking. The 2020 code has a threshold of 20 workers for premises where the manufacturing process is used, carrying power, 40 for premises where it is without power. In 2019, the provision said 10 and 20, so that threshold has also increased. The 2020 law has also empowered the state to exempt any factory from the provisions of the code. So this is a constant process. In fact, this is a process that is visible both in the farm laws and the labor laws. It's just the structure of the laws and the bills and the codes are similar, where the government is taking more and powers for itself, defining less and less, and keeping all the powers for making rules under which it will implement and give essence to the regulatory framework it is initiating. So overall, if you look at these three codes, there are hardly any standards or specific provisions. The codes are open-ended and broad. They give powers to the government to come out with details. The nature of changes in compliance, enforcement of laws, resolution of dispute shows systematically that the labor is being disempowered, and there is a consistent or continuous process of dilution of labor process that gets institutionalized through these codes. So what am I saying overall as a way of conclusion? I think, and the way I look at it, and that's something I would be happy to debate, we feel that India is experiencing a new framing of the development agenda. Till now, till about 2014, as we look at, there was a consistent attempt to take increasing control of capital over labor. But the COVID-19 crisis has provided an extraordinary opportunity to change it in a completely different direction. Earlier, we had in this process where there was, as we frame it, there was a process of deregulating capital and re-regulating labor. In the past, two policies were made in the name of the poor, but benefited the rich mostly. So previous regimes diluted the labor laws, but talked about voluntary regulation. This regime believes that it has the mandate to fully deregulate the labor market, deregulate capital, and re-regulate the labor market. Pushing this agenda at the time of crisis serves another useful purpose, as I feel. It helps out to put the onus of the current precarious condition of workers not on the government, but on the regulatory framework, which is a hangover of the past. And I think this is a very deep political meaning here. So whatever happened in the lockdown, whatever precarity was witnessed, and the vulnerability and death of workers the world and India witnessed, that's something that the onus of that precarity now lies on a regulatory framework, which is a hangover of the past and not a failure of this government. This fits with the larger scheme of things, because now we are a nation which are used to holding the victims responsible as a perpetrators, whether it is the CAA, whether it is the Bhima Koregaon, whether it's the New Delhi riots, and now it's the labor. So those who experience hunger, starvation, unemployment, humiliation, indignity, death during the lockdown are now being held responsible for their own precarious existence. They are being told that the attempt by the state to overprotect them in the past has made them vulnerable. The implication of this rationality is very, very important to be underlined. The third point I want to make in terms of overall conclusion, that the suspension of labor laws does not make sense in terms of benefiting labor or bringing in investment, because we know that we are in a slowdown, and this process of compressing workers' wages and workers' rights is going to further damage, create greater demand shortage in an already stumbling economy. And this squeeze on demand is going to be very harmful for growth. Not to talk about the adverse consequences of this in terms of distribution and also increasing the precarity of India's labor force. Yet, government is preoccupation with changing these laws continues. It's not a case of apathy. It is not a case of incompetence. It's not a case of lack of information. I wish any one of this was true. This hostile attitude to me is intentional and has a cold, calculated logic behind it. Something larger is being attempted here, namely the reinvention and reimagining of labor and labor market in India itself. The distinction among the working class in terms of organized, unorganized, formal, informal, migrant, local are being narrowed out. So basically, a single labor class is going to be created over time, which will commonly experience these hardships and hunger across the board, with as the economy unfolds it. While during the lockdown, we saw that those who have been working did not have enough saving to survive for more than few days. The Jan Sahas survey found that 42% of the workers were without ration within the first few days of the lockdown. So there is a commonality here between the farm laws and the labor laws, and they both attempt to create this vast reserve army of labor for capital. The squeeze on demand in the farm laws, in terms of moving the terms of trade against agriculture, here in terms of making the working class or the industrial working class more precarious and squeezing on their entitlements and rights and their capacity to contest for wages, is a coherent plan to squeeze demand, because that's the only way, as I see it, for it to deal with inflation. And inflation has to be dealt with in order to ensure that the value of wealth, in which the wealth is stored, which is a money form, its value is retained, and also money remains ultimately as a medium of exchange. In other words, the interest of the speculators, financiers, and their assets, the value of their asset is retained. And this requires creation of this continuous process of creation of this vast reserve army, as I see it, in order to ensure that there is a demand squeeze that is experienced. Else, there would be inflationary expectations and inflationary processes that will get introduced in the macroeconomic dynamics. Politically, what does it mean? I think if you look at so many conversations that happened after the lockdown, there seems to be there's an attempt to create some idea of a core labor force. This core labor force will be sort of dealt with in terms of very specific schemes for patronage, transfers of a this core labor force will be the one which will have entitlement rights in the system, accompanied by the technological shift that we expect with the with the new artificial intelligence and the consequent results, outcome of that. There'll be some schemes that will build patronage with a section of the working force, not with the core labor force, but with the other force. There will be a segment of the workforce with which, as I feel politically, relations of neo bondage will be built by regulating the mobility of workers, because there's already a talk that who can migrate, when they can migrate. There'll be a framework around it. So there'll be a control on the avenues of sale of labor power on the whims of capital. All of this is being attempted politically at a time when all rights of labor to organize and bargain with capital is being weakened. Just a last quick point: what does it mean in terms of center-state relations is also a big question, both related with farm laws and labor laws. On labor laws, I will bring to your attention something that Justice Paritosh told me yesterday. December 4, 2020, Economic Times reports, and I quote, according to the official who spoke on the condition of anonymity, said that many state laws may be a divergence with the central courts. Until and unless they are in line with the new courts, the labor reforms undertaken by the center will not have the desired effect. So the government is now thinking that there is an inconsistency or incoherence between the central laws and the state laws. And the state laws were changed during the lockdown before the central courts came in, which were even worse than the central courts. So now the government is talking about nudging the state governments, and the word nudge is very important, nudging the state governments to carry out the exercise where they try and make the state laws consistent and coherent with the central courts. In other words, it will be a race to the bottom, where I think the state governments will be allowed to have a legislative framework which is even more stringent or more anti-labor than the central courts. That would be permitted, but the other way around will not be permitted. That's the meaning of nudge. And government hopes to do this before early January, because on April 1, it really wants to roll out these bills as per the Economic Times report. So this is the overall picture that Chandan, that I want to share.
Thank you very much, Professor Sood. I mean, that was, it was, as I was, admiring the clarity with which you broke down a very complex issue. I couldn't also help feeling alarmed about what to anticipate in the coming months in terms of the health of India's social democracy,
Yeah.
indeed labor democracy. We have a few questions that are being asked, but I have a couple of questions which I thought I might raise now, and before moving on to the questions of the audience. One is, ever since the early 90s, when the big reforms came to be introduced, we have seen alarm being expressed that the labor legislations are being are being tampered with, and are being made friendly towards big business, etc. And you yourself, in your paper, in a chance remark, you notice that even the labor laws that exist mostly on paper, and that they don't really exist in practice, or anyway, or even those laws are trying to be done away with. So I was wondering if you can comment on what is distinctive about this particular effort that we see now compared with the ones we have seen in the preceding years. And I have another question on the response of the labor unions to these codes. How have they responded, and and what has that meant as far as labor activism in the country is concerned? Yes, and I had another question
Should I
about,
say
because
now?
labor is the concurrent subject. I thought, is there any room for maneuver for the states? But you answered that toward the concluding part of your talk. Yes.
On your first question, I mean, that's absolutely true. And I often say that since early 90s, this has been, changes in the regulatory framework for labor has been diluted, but from the back door. I mean, I give you a small example. Look at the inspection rates. See, there is so much talk of Inspector Raj and, compliance cost. But own numbers of the ASI suggests that it has come down drastically. You have now 12% of the factories where inspections are done, while you had 58 or 59% of the factories were being inspected in the early 90s. So the second, I think Gujarat, Indira Hirave did a paper in EPW, I don't remember the year, where she has shown that how many positions of factory inspectors have been lying vacant in Gujarat. It's a very interesting study. So basically what I'm suggesting from these two examples is that the dilution of labor laws was already happening, and effectively the fold of the labor laws, or the coverage of the labor laws is, or regulatory environment for labor, is very limited. Now the question therefore is, what is the compelling need? You could continue with that. Why do you want to really now establish or say it from the front door, so to say it loud and clear that you want to do this? And I think it is because I mean, this is something on which we should have a collective sort of sense of how we read this. But I think politically, it's this finally arguing in public discourse or political discourse that the hegemony, it's the idea of that the labor and the entitlements of labor are to be seen differently. It's not that you are entitled for it, but you're not getting because this doesn't work. It's an implementation failure. No, it is now it's a political argument being made. So it's the hegemony of capital over labor being politically restored. And I mean, I in fact give the example of this all the time. It's an old example that how that hegemony is important. That when the Sindhugram happened and the Tatas had to move from Bengal somewhere, they chose Gujarat as a destination. Now, Gujarat as a destination, you'd be surprised that if you look at the economic survey of the last 3 years when Tatas moved to Gujarat, had highest numbers of strike and lockouts in the country. So it was not that the capital labor relations were most peaceful in Gujarat, and that therefore Tatas who were troubled in Bengal chose Gujarat. My reading is that they chose Gujarat because they were sure that the hegemonic support of the political regime there was with the industry, was with the capital. And I think it is this which is being attempted nationally here, along with, of course, the larger commitment or larger signaling to the global investor. Though it is very clear to me that poor labor legislation, overprotection of labor, or labor cost, none of this is a reason for investments not coming to India. This whole ease of doing business framework, unless it focuses on, because the share of labor in the value added is very low. Okay, so if your share is 6% or 7%, you can't make it zero. You can make it 2 or 3%, because you can't make labor work for free, right? If the share in value added is 6 to 7%, but the share of infrastructure cost is very high, which is where efficiency is required, where we are uncompetitive to China. But that's not the focus. The focus is to build infrastructure, but not in terms of building efficient infrastructure, which brings the cost down. So therefore, that's one. The That's why I said it's a silent takeover. I'm also puzzled as far as labor union response is concerned. They of course went on one day strike. All labor unions have spoken on it. They are highly critical of it. None of them were consulted. All political, I mean, I don't want to be very specific about it, but I must tell you that some leading political parties were running around in the town to get a note prepared on the labor laws a night before they thought it will come to the parliament for discussion. No one knew it was coming. They were running around consulting people to say, let's put a note for the parliamentarians so that they could argue on the floor of the House. It was that silent takeover of labor rights. And when it came, of course, no discussion was permitted. So even that rough note, whosoever may have prepared, didn't go very far. So labor unions have not been able to get the kind of mileage and the kind of which the farmers have been able to get. I see a lot of similarity in the structure of thinking in the farm laws and the labor laws, and also in the method of evaluation, of implementation, and third, the method of getting them approved. Using COVID as an opportunity. So there is a great deal of commonality, and it both work in taking the macroeconomy in the same trajectory. That is cheapening the labor or creating a pool of this reserve army of unemployed. So I think the labor unions have not been able to give the kind of resistance. And if you were to ask me my wish list, I would say that the labor union should join the farmers union now, to ensure that they are heard, and they are heard effectively by the nation and by the governments. This agriculture, there's a question about impact of social security code on women agriculture workers. It's completely bypassed. Agriculture sector, there's not a mention in these codes. Someone has mentioned this here. Mm, of, I mean, is there a purpose in having code for special category of workers? I agree, yes, but we also first must acknowledge that we need social security for all category of workers, because I am little hesitant on these too much categorization of workers. What we are doing is this: we are pitching one worker with his others. Oh, sorry, this was sorry, Chandan. This is on the private chat
Yes,
that you
if
had
you
asked.
put it on the screen, he should put it on the screen. He's not done it, so the audience
Okay.
might not know the question.
There's a.
No, this is the first question, Professor. Maybe you should
Okay.
address this first.
Mhm. So the question is, what might be the impact of social security code on women agriculture workers, who are again vastly differentiated by their conditions of work, such as cane cutters, tea plantation workers, etc. Is it better to formulate a social security from the point of view of specific category of workers? So my answer is yes. We need universal rights, and we need specificity of rights as well, given the context. But too much categorization, too much threshold is something which ultimately leads to this whole discourse that ये बहुत difficult है implement करना. So this business of implementation is actually, to me, not the real problem, because the real problem is lack of political will. The governments implement what they want to implement, and they fail to implement what they don't want to implement. I mean, this implementation failure is not an issue because the laws are too complicated. I mean, you saw my description. You read the laws, you can keep reading the laws for days. They're full of complications. There is no simplification. So yes, we need a social security code which universalizes these rights for all workers and then takes into account. Agriculture is completely bypassed, unfortunately. And women workers as a category do not exist in the discussion on labor codes at all. In fact, we have to extract out what they say specifically for women workers. Otherwise, it's impossible to extract out anything. So it doesn't acknowledge any marginal and vulnerable groups as a special category in its framing of labor laws. why are these called labor codes when they're actually uh, yeah, I mean these are labor codes. This is how the bill was proposed, and I think the formal process. I mean they're effective immediately. But the Economic Times had mentioned something in terms of, and I quote, and it says, that these are notified rules of forecourt and happen to finalize them for January for an April 1 rollout. So I think with the new rules and so on, the government will roll out these codes as laws across the country, because these are effectively laws as far as I'm concerned, because these are the codes which are now laws. The Second Labour Commission has asked for the framing of these codes, because they lead to, this is putting together of many different labor laws into separate codes, 4 codes. Anything else, Chandan?
Yeah, let's just give the audience a minute.
Sure.
But in the meantime, Professor, if there's any point that you feel you didn't have time to elaborate, maybe we should use this time to do that. We have another 20 minutes.
Okay, great. Okay. So, I mean, I'm just to underline what I'm saying is that one is what is being done in each of these codes and the details. And in that, one can ask the question how they are different from past and what new has been added and what it means for labor, on either of these two ways in terms of what has been changed and what has been introduced. So that's one sort of dimension of these changes. But the second dimension, which I think requires actually a lot more collective effort, and the question that you were also asking, in terms of what explains this change. I mean, I cannot find any other reason for the timing of introducing this except the fact that there will be minimal resistance at this point because the Disaster Act is in operation. I cannot fathom any reason really why what was in peril here that you would come out with these codes which are not informed by your own standing committee. I mean, I'm wondering why India's own parliamentary consultative process is given a go by. I mean, except that there is some urgency, and the urgency seems to be this opportunity to pass these laws so that there'll be minimum resistance to it. This is very disconcerting. That itself tells me that the intent is problematic. I mean, if any government is going to bring about any change, even on the farm laws, if you notice, the government has now been forced by farmers to defend itself, to give its rationale, to give its account, to ask its own advisors and its own supporters to write. Before that, the government did not come with any explanation. So government doesn't even believe in convincing its people. So it's not only that the parliamentary process, but even larger citizens. All it says is that if you question it, you are questioning the intent of the government, and the intent of the government questioning leads you into a different category. Then you are dealt with in a different manner. If you deal with substantive issues about the farm law changes or the labor law changes and debate about this, then you say that you don't understand, this is a plan which is of a larger good. Someone said implement it for 3-4 years and let's see. Rajnath Singh said this. I'm surprised. The farm laws say it in writing that after 3 years, no changes in these laws are permissible. It is written in the laws. So how can we be told? In fact, 3 years is a period of learning and modification in the laws. So if you have to not implement the laws, if not implement now, not 3 years later, 3 years later is a fait accompli. So all I am saying is that there is something happening here which doesn't make things transparent and convincing. Yes. And the intent seems to be questionable here.
There's one question that someone just raised. I mean, it's a general question, but I suppose it's important to.
Yeah, existing inequalities in societies. Yeah, I mean, Yeah, very difficult to precisely say in terms of attributing and saying how much, but general disenfranchisement of labor and squeeze on wages are two mechanisms which will impact inequalities, and also the quality of work. We are producing very precarious work. So I think both the farm laws and the labor codes are going to actually enhance the inequalities in India. How else you would explain that in the lockdown, when all of us have faced different levels of difficulties, but the working poor has actually experienced squeeze on their income. Their survival has become that, the stock markets are doing very well. The wealth of certain categories of India's rich has gone up. So the overall inequalities have increased. So lockdown, even in the lockdown, the unequal impact is very clear. So I think that these legislations, as Chandan and I were talking just before this question was asked, the way they have been done, the way the timing has been done, it is to actually strengthen this process of increasing the inequalities. So that's going to be the inevitable outcome. How much inequalities it will increase, I really don't have a forecast, but I think it will worsen it on a much bigger scale. And what you used to call the formal sector workers and informal sector workers, whatever 8% and 92%, etc. This discourse will evaporate. Now we will have a large workforce which will be as good or as bad as the other, except a very technically skilled, what I call the core workers or the top end workers or whatever. I'm not talking about the white collar, but other than that as well, within the blue collar workers, there would be a category which will be the elite workers, and the rest of us will be the same. And all category of workers will be the same. These distinctions will slowly get withered away.
We have another question, which is a variation of the question that I asked.
Well, I mean, this requires slightly elaboration of the response to protest on the farm laws itself. We must acknowledge that people understood what these laws meant at different levels across the country. But the way it was understood in its depth and breadth by the farmers of Punjab and Haryana, just to give you an example, the 3 farm bills are only in English. In the past 5 months, they were translated in the regional languages by the Farmers Union. They were formed small district level and block level committees to discuss this. And the evidence of this is in the fact that you send any journalist to the protest site, you talk to any farmer, he or she will make the right sound, in the sense there will never be a mistake in understanding. Elaboration might be limited or more detailed, but everyone is very clear what these laws mean. So I think in Punjab and Haryana, because of its specificity, that if you look at the way agriculture policy got implemented, the small and marginal farmer, which is the bulk of the farmer, was the beneficiary of the agrarian policy that we had implemented post-Green Revolution. Over time, its income was squeezing. The cost of cultivation had gone up, and so on and so forth. So we know this. So that was the context in which they understood that this change in legislation is going to impact their lives in a substantially, it will take them to a different dimension of living. And they had the collective capacity to create the necessary resistance around it. Of course, deeper explanation will also have to be taking into account the whole history of the region, how it has fought historically the central powers, the cultural elements that exist in the region, which also strengthen, and so on. So basically, there is a very specific context in which the farmers' movement took off. And once it took off and was brought to the attention of the nation, it got the support of the nation, because the moment it has been led in the most, in the best manner possible. It's most peaceful. It's led in a very dignified way. There is a very clear articulation by the farmers' leaders in terms of what they want, clear thinking. There's no confusion. They have been constantly going to the negotiation and insisting on their viewpoint. So overall, it has been done in a manner which has been very effective. And it has also been accepted by India's middle classes, if I were to pay, or even, for at least some period of time, even by the mainstream media. They have not been able to find big faults with it. Any kind of name calling, which worked with the CEA agitation or other agitations, did not work here. And that again is to do with the specific region's history. You cannot call a Sikh peasant or a Punjabi peasant or a Punjabi farmer to be saying anti-national. This is not going to be bought by anyone because of the history that the role that they have played in terms of whether it's the freedom struggle or after the freedom struggle and so on and so forth. So the farm laws could build that kind of muscle where it could get this national attention. Unfortunately, my reading is that the struggles of labor historically have been too divided. And this is because, to use Partha Chatterjee's framework, the categories of governability that the state had created, workers living in slum, a single mother as workers, informal sector workers, steel workers, construction workers, informal workers, bargaining power of this divided workforce is very limited. It's not that it is non-existent. There has to be a moment where it has to come together. Moment it comes together, it will also have the same experience as the farm laws. And I don't see it's very far. It's a moment, in a political process when that cutoff will come, when this will be unleashed, we don't know. But I think there has to be now a collective sense of what is happening to labor in this country, without
Yes.
running into these difficulties and saying how labor is placed vis-a-vis capital and how the state is not fulfilling its responsibility. Because if it is a developmentalist state, it must stand in the interest of the weak and marginalized.
There's a question by my colleague John Kurian.
Mhm. It's a reflection of class character of our organized and its disorganized state of affairs. I normally I don't do this. I'm not part of the trade union movement myself, and to sort of cast a reflection on saying class character of the organized labor unions. But I'm saying it slightly differently and saying that these days the labor market has changed. The factory is not the site at which labor mobilization can happen because of the very nature of how the supply chains have been constructed. As labor unions and as labor whatever experts or people who work in field of labor studies, we have not yet really cracked this code of how do you really mobilize labor in the new globalized supply chain framework of labor. And I think that's the challenge we have to also respond. We must take our responsibility in answering this question of how do you really, because the old understanding about trade union and labor has to be tweaked. And I think political trade unions are grappling with it. They are trying to respond. There's a far greater presence of organized trade unions in the informal sector workers. But that's something that we will have to deal with it in terms of looking at the question of how else we can mobilize labor at different sites. Also, there are stories of contemporaries elsewhere in the world. Yeah, sure, of course. Absolutely. Absolutely. Especially in terms of workers and industrial workforce, there's lots to be learned from other countries. Maybe the other countries now can learn about farmers' protest from us. But mobilizing the workers is something that we need to learn, and also building this larger unity between. Take the example of farmers. At the moment, it is about farmers. There is an understanding about the agrarian crisis, but the agriculture laborer, the Dalit agriculture farm laborer, the women Dalit agriculture laborer is still not prominent part of the discourse of the agrarian crisis. If we need to address this agrarian crisis, it's not only about the cost of cultivation. It's ultimately question of issue of land. It's a question of lack of employment or lack of employment opportunities in farm, in agriculture. So it is snatching away. As someone is saying here, is it snatching away the bargaining power of workers? Yes. But we have to see also what is in place here in terms of, I'm still responding to the previous question that, how do you build resistance? And I think, say, for example, for agriculture laborers or for agriculture households in general, let me say, I was just looking at NABARD data. Only 13% of agriculture labor households earn their livelihood as cultivators. What does it mean? That the remaining percentage of agriculture labor households earn their living by doing multiple occupations. So when you talk about indebtedness in agriculture or the crisis of the rural population in this country, it's a crisis not only of the cost of cultivation, it's a crisis of the linkages of cultivation with other activity. It's a crisis of lack of employment and economic opportunities in rural India by and large. So the agrarian crisis is also much deeper and a broad-based crisis. And unless we unfold these layers of these crises, collective resistance is hard to build. Because moment you build the description of the agrarian crisis in the way I hinted just now, it means there is a great scope of solidarity for resistance across various categories, and the rural-urban divide will not be the most significant divide in those elements of the agrarian crisis. And that bonding between agricultural laborers and the industrial labor can very easily be built. In terms of social protection, in terms of lack of employment opportunities, in terms of weakening of bargaining power, in terms of the precarity of employment conditions, all of this could find a greater bonding between different categories. So I think as analysts, it's our task to show these commonalities, show these interconnections, show these connectivities between different categories. And I am of firm belief that it's high time that we build these connections in order to build a collective resistance, as I said in the beginning, to build a socio-economic policy by a developmentalist state in India, which stands for greater justice and greater equality, a just and equal social and economic policy framework. Yeah, I mean, I've just sort of already touched upon it, Chandan. Bargaining power, yes, it does. Farm laws, they're just, I mean, if you look at the essence of the three farm laws, what it is doing is pushing out. I mean, there are three ones we know: agriculture marketing, the one on contract, and what is the third one? So all these three are something that are reducing the power of both the farmers and agricultural laborers very clearly. It's very funny that the Contract Act says, and the other is Essential Services, Essential Commodities Act. The Contract Act says in the beginning, the first line is it's a written contract. Then it goes down, and it says the state government will tell you whether the contract between the farmer and the sponsorer is going to be a written contract or not. And if it is going to be a written contract, what kind of annexures and documents will be annexed with it. So central government, then it says the state government will necessarily have to implement this act, but the state government can decide whether it wants a written contract or not. So it can be an oral contract also. It can be an oral, unless they come up with rules and says it will not be an oral contract. At the moment, it can be an oral contract written on a cigarette cup, dibbi, saying that's an agreement between you and me. This is how you will cultivate soya bean, and I will buy soya bean if it is of this quality at this price. If I like your crop, if I don't like your crop, it's your headache. So this is the nature of unequal power that they are creating. How much scope do you see for? Well, the kind of intent that the states are showing for farm laws, no state has shown that intent for labor laws. If they do, then there can be a real contestation. Second, the Supreme Court is not examining this question. This question has to be examined. The substantive issue of converting agriculture into agriculture trade and making these legislations by the central government is something that the Supreme Court has not examined. This is the substantive issue, because the federalism issue will get examined whether the central government can intervene. How did it intervene in the farm laws? By looking at trade. So not looking at wheat and rice, but looking at atta and sugar and making the legislation for that. Now, labor is a concurrent subject, but the new legislative framework that has come, it has imposed. This is a quasi-federal structure. I mean, ultimately, if you ask me, the central government finally can implement anything what it desires, and this regime knows. So it's pushing for that. But at the moment, majority of the states are in fact implementing even a worse, poorer version and a more deplorable version of the labor laws. I mean, if you look at what UP is suggesting, what Gujarat is suggesting, what Maharashtra is suggesting, they are even more dangerous. So there is scope for individual states to maneuver, provided Supreme Court comes and stands with it, provided individual states politically can build social support for it. Because at the moment, with the media control, the discourse is hegemonic. Unless the particular state initiates a discourse in its own region and says how labor rights are important for the growth of the state, then only the political class of that state is going to implement a legislative framework which will resist the central government's labor codes. But if the regimes at the state level are going to be of the similar hegemonic idea in terms of that how deregulating labor is the key mechanism through which growth is to be achieved, then I wonder how states can. So it's not only about federalism, it is about also development perspective between the states. And if the management cancels a sick leave without I don't know, it's a very specific question. All employees strike, is that, I don't know. I mean, I've not read anything about that on the code in the codes, but maybe it will come in the rules, and rules have come. Please look at the rules. Maybe there is something I may have missed. I don't know. I can't specifically answer what exactly would it do. Dominant media, I mean, it is actually, it is through the dominant media that this discourse has been built, right? That the key problem of India's development is over-regulation or over-protection of labor markets. This is an idea that would be shared, I'm quite sure, across the board. Even people who think they are pro-labor think that the labor is over-protected. And see my argument that you basically, what it does is it does help the state to actually give up its responsibility towards the workers. It says you are suffering, you're vulnerable because you're overprotected. So if we deregulate you, that is, if we leave it to the market, then things will work in your favor. That's the suggestion. And the media, the mainstream media is carrying it all the time, these ideas. I mean, I looked at some of the work that, some of the writings that Shekhar Gupta did in print at the time when the labor codes were introduced at the state level. And, they and also on the farm, actually, also on the farm bills. And, they actually sometimes misinform their listeners and viewers in terms of how a particular provision has had the consequences of either worsening the condition of labor or benefiting a particular state. And therefore, as I said, non-mainstream media sources will have to be built to make this a competing idea, that actually by taking away rights, you are not diluting the processes of growth. That better growth can be achieved by strengthening rights. At the moment, it is taking away of rights, which is the focus of the key modality for growth. And I think this alternative discourse has to be built. This alternative discourse has to be built by people like us, by non-mainstream media, by social media, and so on and so forth. And that only then, I think we will have a real contestation. So I think ultimately I have also done that. We always hold government responsible for doing this and that, but essentially it is the battle of hegemony of ideas in which we have failed. I include myself responsible. We as economists, as social scientists, we have failed to provide a contesting idea which challenges this notion of taking away of rights as a mechanism for building growth or bringing growth, and growth is essential for the nation. These two ideas need to be challenged, because growth at whose cost, nature of growth, and how rights should be positively embedded in the mechanics and the dynamics and the strength of growth are three ideas we should be building from our various disciplinary vantage points. I don't know. I have no idea of what the political parties did after the passing away of the bills. I don't know. The political parties at that point of time were scrambling to put together a note for them to speak in the debate, but no debate took place. So I see it is not a good sign, because I thought the political parties will be prepared with their responses in any case, because there was already a standing committee for labor on these codes in which all political parties are represented. So I don't think there is an issue of lack of information or lack of competence within the political parties, but just the way government was sort of implementing it, the pace during this time of COVID, where the political parties might not be having access to their their institutional memory, so to say, of the same kind, that there was a bit of a confusion here, and then saying, okay, if tomorrow the bills come for debate, then what do we say? But I'm sure, I mean, they must have, some of the political parties, especially on the left of the political spectrum, have written a lot post these codes on the labor codes. But I don't know about all the other parties, whether how, I mean, each one of them have a trade union, so I'm sure their trade unions have reflected on it. Yeah, I mean, I'm not going to be accusing the labor unions. I'm accusing myself more. We as social scientists, we as economists, we have not responded to the challenges that globalization had, brought in front of us in terms of labor mobilization. How have we responded? Have we come up with a newer understanding of, collective bargaining, trade union frameworks, etc., with a new global supply chain framework? We haven't. So I mean, I'm saying is, I mean, I think one of the farm leaders put it. Someone was asking him, why are you asking for the release of intellectuals and so on? And he responded, I think I heard in television interviews, he's saying that we get our ideas from the intellectuals, from those who write on behalf of the poor and the marginalized. So for us, I think it's our mm, failure that is, I would say, the first failure. And as a result of that, there's a chain impact. The unions themselves have not been able to grapple with these ideas. Chandan, I can't hear you. Your voice is muted, I think.
Yes, it was muted. Thank you. With that response, we come to the end of this session. Thank you very much, Professor Sood, for your talk and for engaging the
Thank you.
question with such patience and care. Um, yeah, this was important for our students and the faculty community to encounter as a this diagnosis that you had to share this afternoon. Thank you again for making time to give us a sense for your views on the matter, and we hope to have you with us again sometime in the future.
Thanks, Chandan, for asking me, and I
Thank-
hope of some use and benefit to your
No, no,
students for conversations later on in your institution. Thanks for asking me to come.